Thank you, Mr. Chairman. Mr. Delaney, I've been listening to your answers about your conduct in the St. Paul's case, and I have to tell you I'm having a hard time following what it is you're saying. You've said now several times that the school only wanted the court case to be tried in a court of law, not in the media. But your attempt to strip anonymity from Chessie was exactly an attempt to try this case in the media, right? It was an attempt to bring her name forward so everybody would know who she was. She's 16. Everybody would know exactly who she was, could look her up, could threaten her, intimidate her. I mean, this was an attempt to put her squarely into the media spotlight nationally, right?
Senator, thank you for the question. I respectfully disagree that the school's intent in trying to require the lawyers to try the case in the court of law was in any way intended to intimidate any of the parties to the case.
How can you say that when you knew full well that a 16-year-old girl would have her name published, would have reporters, no doubt, in her front lawn, would have people following her around with cameras everywhere? Her family's sitting here today. They've already been through hell. Your motion was an attempt to put them through further hell in order to defend your client, right?
Senator, I was an advocate for the school.
I understand that, but as advocates, I have been too. And as advocates, we make decisions, but we're responsible for those decisions. You made a decision here. You made a decision to try to strip a young girl of her anonymity, and you effectively succeeded because you bullied her into it. So she, unwilling to be intimidated by you, went forward and revealed her own name, which took, by the way, tremendous courage. And I'd just like to honor her for her courage in doing that. But you put her to that choice. You did. That was your choice. So that's fine. You made the choice, but now you're accountable for it. So let's have some accountability here. You deliberately did this in a way that would put her at risk, and that was your intent. Have you read the letter that she submitted to this committee?
I have read the letter that was submitted to this committee.
Let me read some of it to you. She says, and I quote, "I remember so clearly reading Michael Delaney's motion from front to back when I came home from my new high school one day, processing what it meant, and then defiantly stating to my parents that after everything I'd been dragged through, from anonymous death and rape threats on the internet to the betrayal of and backlash from my closest friends at school, I wasn't going to let Michael Delaney's dirty tactics bully me, then 16 years old, into shame and silence." She goes on, and this is important. "When survivors of sexual assault, harassment, and abuse come forward to seek some semblance of justice, there is an army of attorneys with a tried and true playbook of tactics to discredit, pressure, and manipulate survivors and victims into silence." Those are the tactics that you use, Mr. Delaney.
Senator, I respectfully disagree with that characterization of the role I played as an advocate in the case. The school agreed to allow the case to proceed with anonymity. I have...
No, you didn't. You filed a motion that specifically to strip her anonymity. I have it right here. I've read it, and I've read your reasons for doing so. The school didn't like the time that the parents and Chessie filed their lawsuit. You complain that counsel filed the complaints minute before the clerk of the court's office closed on June 1st, 2016. Well, I'm sorry for you, but I don't understand why your inconvenience about the time should mean that this young woman should have to surrender her anonymity and have her life. She's a survivor of sexual assault, let's not forget. That already happened. You knew that. Why should she have to have her life further destroyed because you didn't like the timing of the filing?
Senator, I represented the school in that case. I did not represent the Prout family. I understood what they went through. The school felt that the request to restrict the lawyers from trying the case in the media was compatible with her desire to proceed with privacy and anonymity.
I don't understand what you're saying. You filed a motion that sought to strip her anonymity. You told the court that it should happen because you didn't like the time at which her counsel filed their complaint because it put your school at an inconvenience. They had to answer reporter questions, you said. Frankly, that seems to me like a small burden to bear after what Chessie went through. So you made the decision. You forced her to come forward. She was brave and did it, and now you're accountable for that. And quite frankly, I'm astounded you've been nominated. I can't believe we're sitting here having this conversation today. And I, for one, will not support your nomination for these reasons. People who put sexual assault victims through this kind of torture shouldn't sit on the bench. Thank you, Mr. Chairman.
Thank you. Senator Cruz.
Mr. Delaney, this hearing's not going well for you. And there's a reason for it. Because as much as you may be concerned that it's not going well for you, it's gone far worse for Chessie Prout. The focus of this discussion began when a 15-year-old freshman was sexually assaulted by a senior as part of a campus custom known as Senior Salute, a game where upperclassmen competed to have sex with younger students. In 2015, the culprit was acquitted of felony rape, but found guilty of misdemeanor sexual assault and endangering the welfare of a child. You've repeatedly said you were just an advocate. You were just representing the school, where the school was St. Paul's, one of the most prestigious boarding schools in America. And yet, in your representation of St. Paul's, it was St. Paul's that was the victim. You portrayed the school that a sitting U.S. Senator, indeed a member of this committee, attended. Former Secretary of State John Kerry attended. Former FBI Director Robert Mueller attended. A member of the Kennedy family and 3 Vanderbilts have attended. And in your view, that school was the victim, not the 15-year-old girl who was sexually assaulted. Your response to Senator Hawley was, I was just representing my clients. Well, I'll tell you, Mr. Delaney, you represented your clients very poorly. Because as a lawyer, if your client is a school and they've decided their strategy is to out the girl that was sexually assaulted while in their care and custody, that school is doing a crappy job, and the lawyer who goes in and says, sir, yes, sir, happy to do it, is doing a lousy job representing his client. Now, just a moment ago, you answered questions from Senator Cornyn. I actually wrote down a couple of things. Earlier in the day, you acknowledged very kindly that the Prout family, I'm quoting you, the Prout family had a strong interest in anonymity. And then just a moment ago, you answered Senator Cornyn, I wrote it down again, the school did not file a motion to remove anonymity. Mr. Delaney, that testimony is false. I want to read from the motion you filed that is right here. This is on page 2. The school recognizes that JD has an interest in protecting her anonymity. Now notice you told this committee the Prout family had a strong interest. Oddly enough, the word strong was not in your pleading. You graciously conceded they have an interest. Okay? However, in balancing that interest against the prejudice to the school and the public interest in disclosure, the following common sense measures should be taken to mitigate the prejudice to the school, the victim, elite private boarding school. The school shall be entitled to identify plaintiffs and JD during discovery. Plaintiffs and JD should not be allowed to proceed under pseudonyms at the trial of the matter. You asked the court, strip her anonymity. And you just told Senator Cornyn, I didn't ask the court to strip her anonymity. Why did you give a false answer to Senator Cornyn?
Senator Cruz, thank you for the question. I did not in any way intend to provide any misleading answers. The section of the brief that you're referencing involves the use of a pseudonym at trial as opposed to at pretrial phases of the case. And I'm not aware of...
And so your view is it's common sense, that's the word you used, that a teenager, the victim of sexual assault, should be stripped of a pseudonym. That's just a common sense step.
No, I'm saying that First Circuit precedent treats the use of fictitious names before a jury at a trial quite differently than it does at pretrial phases.
So Mr. and Mrs. Prout are here today. Thank you for coming. You and your daughter have been victimized now 3 times. First, on that horrific night. Secondly, when Mr. Delaney, representing the school, went into court and tried to strip your daughter's anonymity, tried to out her against her wishes. And third, when the Biden administration chose to reward him by nominating him to the Court of Appeals. I would encourage everyone to read the letter that Chessie Prout has filed. And Mr. Delaney, there is a reason why virtually every Democrat has skipped this hearing. They're embarrassed about this nomination. I want to read one paragraph from this letter and ask you a final question. From Chessie Prout, if Michael Delaney is confirmed, if an attorney who has brazenly intimidated a minor victim of sexual assault is given the distinct privilege to serve as a judge for the United States Court of Appeals, you are telling victims and survivors that you not only approve of victim intimidation tactics, you reward their enactors with one of the highest legal appointments in the state of Massachusetts. She goes on to say she made this point to the Biden Justice Department. Mr. Delaney, if this committee votes to confirm you, what message does that tell every other victim of sexual assault, child victim of sexual assault, if seeking to out them publicly gets rewarded with a judicial nomination?
Thank you for the question, Senator. I have spent nearly 30 years in my legal career, half of that in public service. I have tried through my work as Attorney General and as a frontline prosecutor to represent the interests of victims in all that I did. I would ask this committee to consider the totality of my record over nearly 30 years as it reviews my qualifications.